for the Honorable President and judges of the Caribbean Court of Justice.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of the Co-operative Republic of Guyana. Hearing of appeal in the matter of GYCV2023-001 between Sasedai Kumarie Persaud versus Sherene Mongroo, Zenobia Rosenberg, Indrani Mulchan. The members of the hearing panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Witt, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Burgess, and the Honorable Mr. Justice Jamada. Counsel may please enter your appearances. Thank you.
May it please your honors, my name is Kamal Ramkaran, and I appear in association with Mr. Harry Ramkaran, Senior Counsel, and Mr. Nikhil Ramkaran for the appellant.
May it please your honors, I am Chanela Glenn, and I appear in association with Ms. Tamara Khan and Ms. Paula Jones Nicholson for the first name respondent, please.
May it please your honors, Nigel Hughes with me, Savannah Barnwell, Sophia Findlay, Adriana Stevens, Nadia Gomes, Ayana Butts, and Michael Jagnandan for the second name respondent.
Your honors, I am C.V. Satram, and I appear together with Mr. Ron Motilal for the third name respondent.
Yes. Good afternoon, Council, and we apologize for the late start. We had a matter this morning, and it went on for a little bit longer than we had anticipated. Mr. Ramkaran, are you ready?
May it please your honors, we appear for the appellant, your honors, Sasedai Persaud, who is present in court. Your honors, I crave your indulgence to join others this morning in welcoming the Caribbean Court of Justice to Guyana. Your honor, I had the honor of appearing before the court in 2014 when it sat here for the first time. I look forward to the privilege, Your Honor, all things being equal, of appearing before the court 9 years hence, when the court sits for the third time in Guyana, if not before. Your Honor, this case concerns Yusuf Mongroo and his last will and testament. Your Honor, he died on the 15th of August 2010 at the age of 82, as stated on his death certificate, page 471 of the record. Your Honor, his two friends who gave evidence in court, Dr. Rohan Jabour and Major General Norman McLean had known him for 40 years. Mr. McLean mentioned 1970. So Yusuf Mongroo was a Trinidadian by birth. So it appears as if he came to Guyana sometime about 1970. Whether he remained here permanently from that year is not known. But he spent a very long time in Guyana and became very wealthy. Your Honor, he never revealed to the people he knew well, the 4 people who gave evidence in this case who were close to him, Rohan Jabour, Norman McLean, Sasedai Persaud, and Indrani Mulchan. He never revealed to any of them that he had children. 2 of the children were plaintiffs in this action, Sherene Mongroo and Zenobia Rosenberg, and all 3 gave evidence in the High Court, claiming various degrees of closeness in the relationship. As an aside, the Honorable Chief Justice found that there was no close relationship, as claimed, between the children and Yusuf Mongroo. When Mongroo became ill, Your Honors, he did what most would do. He sent for his lawyer, Mr. Vidyanand Persaud, now senior counsel. Mr. Persaud took instructions, made notes, the notes, handwritten notes, they're set out at page 490, and drafted a will by hand, set out at page 501 to 503, and then prepared that in a formal document. Your Honor, Mongroo gave detailed instructions, and the instructions that he gave to Persaud, where there was Mr. Persaud had made a mistake, it was corrected subsequently. And he asked his friend of 40 years, Dr. Rohan Jabour, and his attending physician, Dr. Kumar, to witness the will. These unremarkable events, Your Honors, unremarkable for outsiders, not unremarkable for family, friends, and relatives, resulted in the High Court action in which Her Honor the Chief Justice upheld the validity of the will. Resulted also in an appeal to the Court of Appeal, which set aside the decision of the Chief Justice. It now comes to Your Honors, 1,000 pages of record for the final adjudication. Your Honors, permit me at this early stage to mention the will of the case of Gill and Woodall. Its 2011 case, 3 weekly law reports, page 85, paragraph 16. It was mentioned in the decision of Her Honor Justice Gregory. And to quote the short passage, please, Your Honors.
What page of the record is it, you said?
The
you know?
page of the case is 85, but the paragraph I'm citing from is 16. It's about midway down in the paragraph. It says, Your Honors, wills frequently give rise to feelings of disappointment, or worse, on the part of relatives and other would-be beneficiaries, human nature being what it is. Such people will often be able to find evidence or to persuade themselves that evidence exists, which shows that the will did not or could not or was unlikely to represent the intention of the testator or the testatrix, or the testatrix was in some way mentally affected so as to cast doubt on the will. If judges were too ready to accept such contentions, it would risk undermining what may be regarded as a fundamental principle of English law, namely, that people should in general be free to leave their property as they choose. Your Honors, with these circumstances in mind, it ought to be noted that the plaintiffs led evidence of two experts, Glenn Parmesar, a handwriting expert, and Dr. Nihal Singh, pathologist, apart from themselves giving evidence. But their evidence related, in terms of the will, only that the signature did not appear to be that of the deceased. The learned trial judge did not accept the evidence of the expert, Mr. Glenn Parmesar, and in relation to the evidence of Dr. Nihal Singh, Her Honor found that his evidence does not point to total impairment. Those are the circumstances before Your Honors today. In relation to the hearing in the Court of Appeal, Your Honors, I must point to a most striking contradiction that can be observed in relation to the issues of due execution and testamentary capacity and the decisions of Her Honor Justice Gregory and Her Honor the Chancellor. Your Honor, Justice Gregory Gregory upheld the ruling of Her Honor the Chief Justice on the facts of due execution. Her analysis of due execution is at paragraph, page 45, paragraph 88, 89, and 90, page 47, paragraph 100. Her Honor confirmed that it is the domain of the trial judge to find facts and noted the trial judge's finding on due execution. Her Honor went on later to find, and I will deal with this in due course, Her Honor went on later to find that on the facts found by the trial judge, due execution has not been proved in law. Justice Cummings, on the other hand, found that the presumption of due execution was displaced. That is page 918, paragraph 111. Your Honor, in relation to testamentary capacity, Justice Gregory found, and I quote her finding.
Mr. Ramkaran, you're going to come back to these and deal with them in more detail?
I beg your pardon?
You're going to come back to these. You've just touched on due execution.
I will
Section
deal
4.
with it in detail in just a moment,
All
Your
right,
Honor.
so this is just a summary, so I'll wait for that.
I'm referring in this section, I'm pointing out the contradictory nature of the rulings of Justice Gregory and Justice Cummings. I'm just locating them for Your Honors. Justice Gregory found at page 44, paragraph 84, as follows, and I quote, "The ground of appeal that the deceased lacked testamentary capacity to make or sign, and or that the finding of testamentary capacity was against the weight of the evidence must fail, must fail." Justice Cummings Edwards, on the other hand, found at page 914, paragraph 80, "On the totality of the evidence, I find merit in the ground of appeal that Mongroo lacked the requisite testamentary capacity." Your Honors, So we have Justice Persaud, who sat, did not give a decision. Justice Persaud said that he agreed with the decision of both judges. So we have, my submission is that the Court of Appeal on these two issues has not made a valid decision, or at least not being a majority decision on due execution and testamentary capacity. And therefore, my submission respectfully is that the finding of the learned trial judge on these issues ought to be upheld. And the only...
Mr. Ramkar, I'm sorry to interrupt you, but on the due execution, didn't the judges both find that the due execution was not proven?
No, Your Honors. Justice Gregory found, Justice Gregory agreed with the finding of the Chief Justice on the facts.
As to what happened?
Yes.
But
and the Chief Justice found that due execution was...
That's a conclusion of law. The finding of due execution is a conclusion of law. What Justice Gregory found was that the facts that the trial judge found, Chief Justice found the facts, but then Justice Gregory went on to say, however, when you apply those facts to the requirements of Section 4, the requirements of Section 4 were not satisfied, hence her comment that there was not due execution in law.
Yes, sir.
Okay. The Justice Cummins also found that the evidence displaced the presumption of due execution. So in other words, that there was no due execution. So I'm just asking you, you just said to us that in the Court of Appeal, there was no unanimity around both due execution and capacity. But I'm taking you back to due execution. Would you not agree that in the Court of Appeal, to the extent that Persaud agreed with both, that Cummins and Gregory both found, through different routes maybe, that there was non-compliance with Section 4? Would you not agree with that?
No, no, Your Honor.
Okay. All right, fair enough. Let's move on.
For this reason, I will seek to demonstrate to Your Honors that Justice Gregory erred when she found that due execution was not proved in law. Now, if you remove...
No, fair enough. She may have erred, but she concluded, her opinion was that the requirements of Section 4 were not met. Maybe erroneously, but...
Well, I accept.
So
yes,
the point I'm on is, I do not think it is fair to say that there is a contradiction in opinion on due execution. There may be errors, but not a contradiction, because I think they both found, and Justice Persaud agreed, that there was not due execution.
There is no contradiction in the final outcome of the decisions between two judges. I'm saying, Your Honors, respectfully, that there is a contradiction on the findings of fact between the two judges. And the reasoning of Justice Gregory on the law cannot stand up to scrutiny. And what are we left with? If Your Honors agree with me, at the end of the day, what we are left with is that Justice Gregory says that due execution has been proved on the facts. At the end of the day, if you agree that her conclusion on the law is wrong, we have her saying that due execution is proved on the facts, and the Chancellor saying the opposite. That's my contention, Your Honor.
Yeah, I just trying to grapple with all you're saying, and I apologize for the mask. It's precautionary. Mr. Ramkran, what is the error of law that you see that these two judges utilized? What error of law did they commit in coming to the conclusion that Section 4 had not been complied with?
Your Honor, in a nutshell, Justice Gregory found that there was no compliance with Section 4 of the Wills Act on the basis of 4 authorities where 3 or 4 authorities, and I'll mention them in a minute, I wouldn't go through them, Your Honor, but where the cases where the testator signs or acknowledges his signature in the presence of one witness, and where the second witness came and signed as the second witness. In those cases, for reasons other than the fact that the witnesses signed at different times, the court held that the wills were not valid. Justice Gregory concluded from those cases that where the witnesses were not present when the testator signed the will is invalid. Justice Gregory failed to take account of the fact that Section 4 of the Wills Act provides for acknowledgement. An earlier signature, acknowledgement of that signature in the presence of the witnesses.
So, Mr.
That is
Mr.
my
Right,
contention.
fair enough. But Mr. Amber, can we look at Section 4? Do you have Section 4 before you? Could we just look at the language of it for a moment, since we're there now?
Yes, Your Honor.
The Wills Act.
Section 4 said the will must be in writing. It must be signed at the foot or end by the testator. The signature must be made or acknowledged by the testator
Fair enough.
in the presence of both witnesses.
So let's put a little pause there. In writing, signed at the foot, signed or acknowledged by the testator, right?
Yes, sir.
So signature or acknowledgement can suffice up to now.
Yes, sir.
Okay, let's read on, because there's no full stop after that. It continues.
In the presence of 2 or more witnesses present at the same time.
So let's pause. The signature or acknowledgement, either one, correct,
Yes, sir.
must be done, signed or acknowledged in the presence of 2 witnesses present at the same time.
Yes.
Is
sir.
that what it says?
Yes, sir.
All right. Are those the facts of this case?
I beg your pardon?
Are those the facts that the Chief Justice found? Are those the facts in this case?
The Chief Justice found that the will was acknowledged in the presence of 2 witnesses at the same time.
Hold on. The section says the testator must acknowledge it. Let's stay with acknowledgement. The testator must acknowledge it in the presence of the 2 witnesses who are, in parentheses, both present at the same time.
Yes, sir.
All right. Did the testator acknowledge it while both witnesses were present at the same time? So it's not that Peter acknowledges it to one and then to another one.
The testator, in this case, the testator acknowledged his signature in the presence of both witnesses at the same time, and the Chief Justice so found.
Correct. Can you show me that in the Chief Justice's opinion, where it is said that the testator, in the presence of both witnesses at the same time, in other words, 3 people are present, testator is present and both witnesses are present, and the testator says, yes, this is my signature, while both are present. Where is that evidence? Where is that evidence?
The evidence that both witnesses are present at the same time?
Or at the same time when the acknowledgement was made. Because if you are right on that, then the formal requirements, would it appear, be satisfied? Contrary, I accept, to what the judges in the Court of Appeal said. So this is a critical piece of evidence. Sorry?
Your Honor, at page 294, the evidence of Dr. Jabour, page 292. Page 292, Dr. Jabour said, I asked him if he signed the will, and he said yes. Page 294, Dr. Jabour said, we were together at the same time, and that is when he signed the will. That is
So who is we?
Mr.
Who is the we?
Dr. Kumar. We talking about Dr. Kumar, Your Honor. You have to go up a little bit, and you will see that he's talking about Dr. Kumar.
So therefore...
That's not the only evidence,
No, wait,
Your Honor.
pause. So therefore, is that evidence then that Dr. Kumar and Dr. Jabour were both present at the same time when he signed?
That's not the only evidence, Your Honor. Just permit me. At page 350 of the record, in answer to the question by Mr. Ramjatan, where was Dr. Kumar when he signed, where was Dr. Kumar when he signed the will? He was at the foot of Mr. Mongroo's bed in the room at the hospital. 2 paragraphs later in the same page, Dr. Kumar said, there is only one place to sign in the room, and that is the bed table. I signed, and then Dr. Kumar signed. This was a transaction when they were both present. Yusuf Mongroo acknowledged the will, and they signed.
So did Mr. Mongroo sign at that time?
Mr. Mongroo did not sign at that time, Your Honor. He signed before.
So that you say is evidence that they both signed in his presence.
They both signed in his presence.
And the evidence of acknowledgement is?
The evidence of acknowledgement is...
So he has signed the will before. He has signed the will.
He had signed the will.
Now you say this evidence says that the two of them come in by the bedside table and they sign.
Yes.
Okay.
In the evidence of Dr. Jabour, Dr. Jabour talks about the acknowledgement, Your Honor. And they're different at different places. Dr. Jabour said that Dr. Kumar was present. And Dr. Jabour said early in his evidence, I think it's page 292.
Could you just give us the page numbers where that evidence is to be found? 350?
You told us 292 and 350.
At page 292, I asked him, there's a long passage there, Your Honor. I don't want to read the entire thing, but the final penultimate sentence, he said, I asked him if he signed the wills, and he said yes.
Who is the him? Who is the I and who is the him?
I is Dr. Jabour.
Right.
He is giving evidence.
And
he's talking to Mr. Mongroo. And he asked Mr. Mongroo if he signed the will. And
Mr. Mongroo says yes.
he said yes.
Yeah. And where is Dr. Kumar?
Page 294, Your Honor.
This is the same scene. Nothing has changed.
Page 294, Your Honor.
No, what I'm asking is, when you just read what was on page 292, yes?
Yes, sir.
Who was in the room at that time?
Dr. Jabour did not say who was in the room
Right.
at that time.
So that the only inference we can draw is that Dr. Jabour was there with the deceased.
We ought not to draw that inference, Your Honor, because this is what Dr. Jabour said. At page 294, he said, in answer to Mr. Ramjitan, what it says here in paragraph 2, we were together at the same time. That is when he confirmed that he signed the will. And they were talking, the paragraph before that, about Dr. Kumar. I was there first.
The we were together. Is that Dr. Jabour and Dr. Kumar?
Yes, please, Your Honor,
Or
because
Mr. Mongroo and Dr. Jabour?
in the paragraph before that, Dr. Jabour is talking about Dr. Kumar.
Right.
He said, Dr. Kumar and I saw him every day together. I would usually be there from first. What is stated in the affidavit is an accurate reflection of what went on. I was there first as a friend questioning him about the document, and then Dr. Kumar came in.
Could you read on? Could you read on, please, counsel?
I don't think Dr. Kumar saw me sign, but he's changed that later on, Your Honor. He said we were together at the same time.
Counsel, what I have, and you have the record, so you can correct me if I'm wrong. He said that Dr. Jabour further stated that he affixed his signature to the will, and Dr. Kumar came in afterwards and he told him, I'm not sure, that he was satisfied that this is what Yusuf wanted, and Dr. Kumar signed the copies of the will in his office. What do you make of that, counsel?
Well, Your Honor, Dr. Jabour said at first that Dr. Kumar was not present when he entered first. He changed that evidence. He corrected himself later on.
You say he corrected himself, but that is for a judge to decide which.
The judge did decide, Your Honor.
Which version?
I haven't decided that.
Right.
I'm telling, I'm submitting to Your Honors.
The Chief Justice found that it was done in the presence of each other.
And this Chief Justice is the only person who can properly find that. We can only advocate, as I'm advocating now. Her Honor, the Chief Justice accepted that the will was signed by Yusuf Mongroo in the presence of, the will was acknowledged by Yusuf Mongroo in the presence of Dr. Kumar and Dr. Jabour at the same time. And that is the evidence. Dr. Kumar corrected himself. He first said that Dr. Jabour corrected himself. He first said that Dr. Kumar was not there. And later on, he changed that, and he said that Dr. Kumar was present. Your Honor, his affidavit, his attesting affidavit to a Barbados will was tendered by Sherene Mongroo, not by Dr. Jabour, by Sherene Mongroo. Dr. Jabour was shown that attesting affidavit. That attesting affidavit is at page 467 of the record.
That's the Barbados will.
That's on the Barbados will. He reminded himself, Your Honor, and at paragraph 2 it said, the said testator executed the will on the day and of the date thereof, by acknowledging the signature Yusuf Mongroo as the same now appears thereon to be the signature of the said will in the presence of me and Dr. Kumar, the other
Mr.
subscribing witness.
Is that the will that is the subject matter of this appeal?
I beg your pardon?
Is that the will that is the subject matter of this appeal?
No, Your Honor.
No.
But this is evidence that was led in court by Sherene Mongroo. When Dr. Kumar gave his evidence, he was shown the document. You said Dr. Kumar was not there. What about this? He said, oh yes, I remember now. He said, I'm 68. I see 30 patients every day. The deceased died in 2010. This is 2014. My recollection, I now recollect. And the Chief Justice accepted that, Your Honors. Explicitly.
Could you just read that passage from the record?
Which passage?
The passage that you just quoted, that he said, oh, I now remember, and so we could take a note of what page? And could you also, counsel, read how the Chief Justice analyzed what Dr. Jabbour had said before, and how he, in your words, corrected himself? Could you do those two things for me, please?
The page in the record of the evidence, Your Honor, where Dr. Jabbour said what I'm saying and referred to the affidavit after he got his recollection intact, was at page 294, Your Honor. Your Honor, at page 293, at the very first sentence, Dr. Jabbour said, I was questioning him about the wills which I was doing as a friend. Dr. Kumar was not present. When he was shown the affidavit, did you sign this affidavit? This is what you said. Which one is true? He said Dr. Kumar was present. That happens every day in court, Your Honors.
But what I'm just trying to get clear in my mind, this case was about the Guyana will, correct?
Yeah.
The document that Dr. Kumar was shown was what he said in relation to the Barbados will.
Yes, Your Honor, but all of the documents were being signed at the same time. The Barbados will, it's in the evidence, Your Honor.
So all the wills were signed at the same time.
The Barbados and the Guyana wills were all together signed at the same
The
time.
Cayman Islands will was not at the same time. It was a different date, wasn't it?
I beg your pardon, sir?
Is it Cayman Islands? Is it the other will?
I don't know about the Cayman Island.
When there 3 or 4 wills? The 6th of August was the Cayman Islands, the 12th of August was Barbados, the 12th of August was Guyana.
I don't know, we don't know about the Cayman Islands will, Your Honors.
That's not
We know
part of
about the
record.
Barbados and the Guyana wills.
Okay.
They were signed at the same time.
And the Barbados will was not challenged, was it?
The Barbados will has not been challenged, Your Honor. So there was a contradiction in the evidence. I call it a correction. He said that Kumar was not present. And then when reminded about the affidavit, he said, oh yes, I forgot. Why you forgot? I'm 68. I see 30 patients a day. And this happened 4 years ago. And the trial judge believed his evidence. The trial judge didn't only believe his evidence. Your Honor, I would say the trial judge effusively believed his evidence. trial judge had no doubt at all about Dr. Jabour's evidence.
And Dr. Kumar did not testify, correct?
The trial judge found at page, sorry, Your Honor.
Mr. Ramkran, the Dr. Kumar did not testify, is that correct?
Dr. Kumar did not testify, and Her Honor, the Chancellor made reference to Dr. Kumar not testifying on several occasions in her judgment, as if this is it was a big problem. Your Honor, I cited in my submissions a passage from Halsbury that says that one witness, as well known, Your Honor, in this litigation, one witness, one of the two witnesses is sufficient. But not only that, Your Honors. Dr. Sasedai Persaud, the appellant, gave evidence and pointed out that she went and asked Dr. Kumar to give evidence. Your Honor, her evidence was not allowed because of the objection to cross-examination. But this is what she said, Your Honor, at page 401. I know Dr. Kumar. I was present when he was asked to testify. Objection to hearsay evidence. But she continues, and this was allowed in. I did not succeed in getting him to come to testify. He was asked, Your Honor. Your Honor, this is what Her Honor said about Dr. Jabour. Page 697, paragraph 172. Dr. Jabour's evidence about the execution of the wills is paragraph 174. Dr. Jabour's evidence about the execution of the wills is also accepted in the light of the authorities noted below and the consideration of the evidence in this regard. Her Honor accepted the evidence of Dr. Jabour not only in relation to Jew execution, but in relation to other matters. Her Honor has no hesitation in accepting the evidence of Dr. Jabour.
I think you can move on from section 4 now, maybe. Yeah.
Your Honor, is there a question about section 4, Your Honor?
No, I'm saying I think you can move on from section 4. There are other areas I think you want to cover. Is there anything else in the evidence on section 4 you want to bring to our attention, or that's it?
Not as far as Justice Gregory is concerned, Your Honor. What I was saying before, on Justice Gregory, before this diversion, is that Her Honor used cases and wrongly applied section 4 to those cases, which does not really apply. Her Honor's misconceived what section 4 was saying, that you can acknowledge. Her Honor is saying, if the testator signs the will but not in the presence of two witnesses, those are the cases she cited, and concluded from that the testator must sign the will, sign the will in the presence of two witnesses. She did not touch the issue of acknowledgement. Your Honor, in relation to testamentary capacity, I touched on that, Your Honor. Please permit me, Your Honor, in closing off this section, to refer to the case of Couser and Couser, or Couser and Couser, C-O-U-S-E-R. It's not listed in the list of authorities. I'll give Your Honor the reference. COUSER and COUS against COUSER. It's a 1996 case. It's reported at 1 Weekly Law Reports at 3/13/01. This is a case which does not support the cases cited by Justice Gregory. In this case, the testator signed his will and took it to the home of a married couple who were his friends to witness it. The wife was home and signed as a witness. The husband was not home. The husband came in a while after, and the testator asked him to sign. And he signed the will in the presence of the wife and in the presence of the testator. The testator first having acknowledged his signature for the second time. He acknowledged his signature to the wife when he first came in. When the husband came in, he acknowledged his signature to both husband and wife for the second time. And the wife was challenged by the testator's son by another marriage. It was held, Your Honors, when a will was not irregular on the face and the intention of the testator was clear, there is a heavy burden on anyone seeking to rebut the presumption of regularity. And the court ought not to search for defects in what had occurred. That valid acknowledgement of a signature under the Act required that there should be visual contact between the parties concerned, that the events whereby the execution had taken place constitutes a continuous functioning of the three parties, so that when the testator acknowledged his signature a second time after the husband's arrival, he did so in the presence of the wife. Accordingly, the testator acknowledged his signature in the presence of two witnesses present at the same time. Your Honor, this case, I cited this case in the...
Thank you. Just to tidy up this then, so is it that both witnesses, you say he acknowledged it in the presence of both witnesses, we've covered that ground, yes?
Yes, sir.
Did both witnesses attest to it at that time?
No, Your Honor.
So that they attested to it, they signed it at different times?
At different times.
And that is fine, you say, according to Section 4?
That is fine according to...
So the only requirement, they don't have to sign in each other's presence, you say? The testator can sign or acknowledge...
The Act doesn't say so, Your Honor.
Right. Section 4 does not require that they attest in witnesses, that they attest in the presence of each other.
No.
Section 4 doesn't require that.
It does not. Section 9 of the UK Act says so specifically. Section 4 of the Guyana Act does not say so, but it does not say that they must sign in the presence of each other.
So, in other words, you're saying that the testator can sign it, the witnesses could sign at different times as long as the testator acknowledges his signature when they're both present together?
Yes, Your Honor. Yeah.
You want to just read for me the end of Section 4?
I beg your pardon?
Can you just read the end of Section 4 for me, please?
Has a long ending, Your Honor.
No, but the part that says his signature be made and acknowledged in the
And
presence.
those witnesses shall attest and subscribe in the presence of the testator. But no form of attestation shall be necessary.
Right. So it doesn't say in the presence of the testator and each other.
No.
That's in the English Act. That's not in Guyana.
That's specifically in the English Act. It's not in the Guyana Act. But the Guyana Act does not say that they must sign in the presence of each other.
Yeah. Okay.
Your Honor, if I can move on to to the issue of testamentary capacity. Your Honor, Justice Gregory well, there's the issue of Justice Cummings Edwards quickly, Your Honor, I referred to Justice Cummings Edwards' submissions, arguments, her conclusions on due execution at paragraph 3.1 of page 937. Those were my submissions. And I referred to paragraph, I analyzed in those submissions paragraphs 92, 94, 102, and 108, in which Her Honor speaks to the issue of due execution. And Your Honor, Justice Cummings Edwards says, for example, at page 94, paragraph 94, there is no evidence that the signature of Mongroo was acknowledged. Her Honor says things which are completely against the evidence. That is not the evidence. The evidence is that it was acknowledged. There's no evidence that it was not acknowledged. And the Chief Justice found that it was acknowledged. And Dr. Jabour's evidence that I was reading a moment ago said that he acknowledged. Then Her Honor goes on to say, contradictorily, apart from Dr. Jabour's testimony, there is no evidence of attestation and signature. So what really is Her Honor saying? Her Honor says that there is no evidence at paragraph 94. There is no evidence either that the witnesses saw Mongroo's signature or had the opportunity of seeing it. Your Honor, if you look at the will is exhibited at page 464, 465 of the record. If you look at the will, they had the opportunity of seeing Mongroo's signature because all his signatures are on one page, or on the last page. Yusuf Mongroo, Rohan Jabour, first names Dr. Kumar. So they had the opportunity. Her Honor concludes paragraph 94, the requirement that the witnesses sign in the presence of the testator or sees the witness sign has not been met. Your Honor, there are many, many passages that Her Honor, Justice Cummings, are questionable. Your Honor, she mentioned Dr. Kumar. Dr. Kumar should have at least been called if he was available. Dr. Kumar was not present to testify. Your Honor, Her Honor assumes that Dr. Kumar's evidence was necessary as a corroborative crutch.
Just because you have a time limit, we're still on Section 4 compliance. I think your point is that the evidence of Justice Cummings Edwards, it doesn't line up with the evidence. Her findings don't line up with the evidence. Yeah?
Your Honor, I haven't been able to touch testamentary capacity, but
so
I
that's
will
what I'm saying.
cite,
So maybe you should come off Section 4. I'm just suggesting if you want to and cover the other grounds that you want us to consider.
Your Honor, I have my junior will need a few minutes to conclude. There. Your Honor, in testamentary capacity, unlike the issue of due execution, there is a straight conflict in finding. Her Honor says one moment, please, Your Honor. After a long analysis, Your Honor, Justice Gregory concludes at paragraph 84. For the reasons discussed earlier, the ground of appeal that the deceased lacked testamentary capacity to make or sign a will, and or that the finding of testamentary capacity was against the weight of the evidence, must fail. Her Honor Justice, there's a long analysis, Your Honors. We don't have the time to go into it. Paragraph 72, 73, and 75 of Justice Gregory's decision. The Chancellor, Your Honor, an equally long analysis from paragraphs 47 to paragraphs 90, page 909 to 914, deal with testamentary capacity. And Her Honor concludes, accordingly, on the totality of the evidence, I find merit on the ground of appeal that Mongroo lacked the requisite testamentary capacity. Your Honors, I don't have the time to go into the lengthy arguments I had prepared to prove to Your Honors that Justice Gregory was wrong. But just this snippet, Your Honor, if you will permit me.
You mean that Justice Gregory was right?
The Justice
You
Cummings.
want to say that Justice Gregory is right?
Justice Gregory was right, and she justified herself.
No, you said that Justice Gregory was wrong. But
No, sorry, I made a mistake. Justice Gregory was right. Justice Cummings erred, Your Honor. And this is what Justice Cummings said at paragraph 50, page 909. The issue to be considered is whether Mongroo had testamentary capacity to execute the will, assuming the will was made by him. Your Honor, that is not the function of the Court of Appeal. The function of the Court of Appeal is not whether Mongroo had testamentary capacity. That's the function of the judge. That's the function of Her Honor, the Chief Justice. And Her Honor, the Chief Justice did decide that Mongroo had testamentary capacity. After extensive analysis of the evidence of Mr. Vidyanand Persaud, Dr. Nihal Singh, Mr. Rohan Jabur, and so on. And I close with this passage, Your Honors. Another passage in Gill and Woodall. It is, of course, a very well-established principle. Is a principle which Your Honors are very much aware of. It is, of course, a very well-established principle that the Court of Appeal does not lightly interfere with findings of fact made by a trial judge. In particular, the mere fact that this court concludes that it will probably not have reached the same decision on the facts as the trial judge is not a proper reason for overturning his conclusion. Before overturning a first instance finding of fact, we have to be satisfied that the trial judge reached a conclusion that he could not necessarily have reached, or made findings of fact which were not open to him on the evidence, or made some other fundamental error which vitiates his finding. Your Honors, because the Court of Appeal approached this matter in the manner of which a trial court ought to approach it, the Court of Appeal fell into error. Thank you very much, Your Honors. My junior, Mr. Kamal Ramkran, will utilize the few minutes remaining that I have left, please, Your Honor.
May it please Your Honors, it is often important, Your Honors, for us to remember our roles in the trial process. Your Honors expect of lawyers, such as myself, that we will present our cases with candor and accuracy. Lawyers expect that Your Honors will give fair and reasoned judgments. And we all expect that the trial judge will listen to the evidence, take advantage of the opportunity to see and hear the witnesses, and make the best of that by analyzing it and sending that evidence onwards, finding the facts and sending them onwards on appeal. Your Honors, I was not involved in this case before this court, and I began preparation by reading the judgments. And on reading the judgment of the Chief Justice and then the judgments of the Court of Appeal, one can see quite clearly that the Chief Justice utilized our opportunity, listened to all of the evidence, and masterfully analyzed it. In fact, the Chief Justice recognized her role immediately. At paragraph 4 of her decision, she said that paragraph 4 of her decision is on page 669, please, Your Honor. She says in the last sentence of paragraph 4, this case turns on the facts and credibility of the witnesses. She knew right away what her role was in this case, and she went on to do her job to the highest quality, as she always does. Your Honors, there are reams of cases on how appellate courts should treat the findings of facts by trial judges. Your Honors have given decisions on it. My personal favorites are McGrady and McGrady. Reported, I apologize, Your Honors, I have not put it before Your Honors, but it is pretty well known. And the citation is 2013, One Weekly Law Reports at page 2477. And the other case is Haq and Rahiman. As Your Honors are in Guyana, I thought it fitting to find a Guyanese case which sets out how the Court of Appeal should treat the trial judge's findings of facts. Haq and Rahiman is reported at 1977, 27 West Indian Reports at page 109. These statements are well known by appellate courts on the function of a trial judge, and I hope you will permit me just to refer to a few from McGrady and Haq and Rahiman. In McGrady and McGrady at page 2480, Lord Reed said, the appellate court must be convinced by the plainest considerations that it would be justified in finding that the trial judge has formed a wrong opinion. But if Your Honors look at the judgments of the Court of Appeal, where is that wrong opinion of the Chief Justice? The Court of Appeal approached the case by recounting the evidence and saying what they believe the result should be. In my submission, Your Honors, the Court of Appeal should have said, this is what was found by the trial judge, and this is why it is wrong. And this is why we cannot uphold the findings of fact by the trial judge because she fell into error by doing this or that. The Court of Appeal did not do that. The Court of Appeal simply recounted the evidence and gave their own judgments on what they believe that evidence meant, without regard to the findings and analysis of the Chief Justice. But upholding the trial judge's findings of facts, Your Honor, is not only deference to the fact that the trial judge sees and hears witnesses when appellate courts do not. It is also because judicial time is wasted if every court has to find what the facts are. In McGrady and McGrady, Your Honors, the Lord Reed referred to Anderson and City of Bessemer, a 1985 United States Supreme Court decision. The court said, duplication of the trial judge's efforts contribute only negligibly to the accuracy of fact determination at a huge cost in diversion of judicial resources. And then they went on to say, the parties to a case on appeal have already been forced to concentrate their energies and resources on persuading the trial judge that their account of the facts is the correct one, requiring to persuade
Mr. Ramkaran, I don't think you need to labor before us the role of the trial judge as a primary finder of fact and the regard that has to be had to that.
Certainly, Your Honor.
I think that we have a pretty good grasp of that. If there are two cases that you did not put before us, maybe you can give us those citations.
The one is McGrady and the other is Haq and Rahiman.
And are there any particular references, any particular paragraphs that we can focus on in them? If they're stating the general principle that is well known, then just give us the citations and the paragraphs.
Your Honor, for McGrady and McGrady, the citation of which I've given you, which I can give again, is 2013 One Weekly Law Reports 2477. I rely on pages 2480 to 2481 and 2487 in the judgment of Lord Reed. Lord Reed gave the judgment of the court. In Haq and Rahiman, which is 1977, 27 West Indian Reports, page 109, I refer to the judgment of Justice of Appeal R.H. Laku at page 116.
No, thank you very much.
Just in summary, Your Honors, in those cases, one, you're wasting judicial time by trying to find the facts again, and two, the judges spent a lot of time, days and months with the case where the Court of Appeal has not. If Your Honors look at the beginning of the Chief Justice's decision, you will see how long she spent on it. Months and months she sat and took evidence in this court, in the court in this matter. So that is not to be taken lightly by an appellate court. She saw and heard the witnesses, and even if everything is not accounted for or recounted in the judgment, it is to be taken that she placed emphasis on it and considered it. Your Honors, the Court of Appeal did not, on the last point on facts, the Court of Appeal did not say why the trial judge fell into error and why they felt it necessary to change, to make their own findings of facts. The Chancellor only at pages 922 and 923, at paragraphs 138 to 141 of her judgment, set out a number of authorities saying that an appellate court could, in certain circumstances, find its own facts. And at 142 of paragraph 142 of her judgment, saying that the weight. One moment, please, Your Honor.
We're saying that the Court of Appeal gave no basis for differing from the findings of the trial judge, or to put it another way, there was nothing in the Court of Appeal's judgment to indicate why the trial judge's findings should not stand. Is that what you're saying?
Yes, please, Your Honor. And I would go on to say that it is impermissible to do so. If you want to differ with the trial judge, you must say, this is what she found, this is how it is wrong, and this is why I do not agree with it. This is why, and perhaps you can do that with inferences, but primary facts, you have to have a very, very strong justification for doing so, even inferences in my submission, Your Honors. Your
I
Honors,
believe we follow you, Mr. Ramkran.
I'm very grateful, Your Honor. Your Honor, there's another issue.
You're running short of time, eh? You're running very, very short of time.
How many more minutes, Your Honor? 5? 1 or 2? Your Honors, there is, in the decision of the Chancellor, she referred to a concept such as stricter proof, where knowledge and approval was concerned. She said where there is a weakness of the testator, rendering him liable to be made the instrument of those around him, you need stricter proof. Your Honors, I would submit that stricter proof is loose language, and it is not clear what that means. The burden of proof in a case such as this was set out in Key and Key, which is referred to by the Chancellor in her judgment. That burden, Your Honor, so at paragraph 97 of Key and Key, Justice Briggs said, where a will is duly executed and appears to be rational, as is the case with this will, then the court will presume capacity. The evidential burden then shifts to the objector to raise a real doubt about capacity. If a real doubt is raised, the evidential burden then shifts back to the propounder nonetheless. Now, no stricter proof is referred to here. And the evidence itself shows, Your Honors, that the testator.
Karan, I think, I mean, you know, we can play around with the language a little bit. I think all that they were saying there was the evidence of Dr. Singh. You remember the evidence of Dr. Singh, right?
Yes, yes, Your Honor.
Evidence of Dr. Singh was that because of the deceased's mental condition, that he was of the opinion that about, I think, 2 weeks before, therefore covering the time of the execution of the wills, because he died a few days after. Is that not right?
Yes, yes, Your Honor.
So that 2-week period prior, he thought that, you know, his general ill state and his state of his brain, etc., that, you know, he would have some weaknesses in memory and recollection. So the impression I got when I read the judgment was that all that was being said there is where you have those circumstances, one has to be a little more careful. So
Certainly, Your Honor.
I wouldn't describe the language as loose.
Well,
I think
stricter
it's
proof, Your Honor, is either the burden or the standard of proof. I'm not sure which it is.
The burden is on a balance of probabilities.
Yes,
but
yes, Your Honor.
But if the circumstances of the testator are such that the medical evidence suggests that the testator was in a weakened state or ill or ailing, then you naturally want to be a little more careful about testamentary capacity. So I don't think it was saying more than that, but I think we take the point.
Your Honor, I would only suggest
I
that
wouldn't suggest it's an error of law.
Certainly, Your Honor. I would only suggest, Your Honor, that where there were 3 witnesses at least who saw Mr. Mongroo while he was alive and interacted with him, on the one hand, he took away the blood transfusion form from Ms. Mulchan, signed it himself. He spoke to the lawyer a few days before and went through the bill. And on the other hand, you have Dr. Nihal Singh, whose first interaction with him was 5 days after he was dead. He never knew him, never interacted with him, never treated him. So his only interaction with Mr. Mongroo was 5 days after he was dead. The postmortem was done on the 20th of August. Mr. Mongroo died on the 15th of August. I would suggest that, I would submit to Your Honor that the Chief Justice was entirely correct in accepting the evidence of those who saw and interacted with Mr. Mongroo and in not accepting the evidence of Dr. Singh. And that the Court of Appeal was fell into error in requiring something more than the trial judge gave. Your Honor, I'm very grateful, Your Honors.
Thank you, Your Honor.
That there are, what, three respondents? We would like you to be all saying the same thing.
Guided, please, Your Honor. It shouldn't be long, Your Honor. Your Honors, I wish to first begin by saying that we will be relying on the written submissions that were filed on behalf of the first name respondent, please, Your Honor. I will not attempt to regurgitate what is stated there, but for the purpose of the addresses this afternoon, I merely wish to touch briefly on grounds of appeal A, C, and F, please, Your Honors.
Yes.
Ground of appeal A deals with the due execution of the will, please, Your Honor, to which Section 4 of our Wills Act states expressly what is required. I must also state, please, Your Honor, that these requirements are mandatory, please, Your Honors. That section says that the will must be in writing, it must be signed by the testator himself or by another person on his direction. The testator's signature must be made or acknowledged in the presence of 2 or more witnesses, and those 2 witnesses must be present at the same time and shall attest and subscribe the will in the presence of the testator. The will that is the subject of these proceedings, please, Your Honor, deals with an acknowledgement as opposed to a signature by the testator in the presence of the witnesses, please, Your Honor. Acknowledgement, when used within the confines of the Act, as per the words of Justice Lushington in Hudson and Parker, please, Your Honor, is, or rather the judge poses a question, what is the plain meaning of acknowledging a signature in the presence of witnesses? What do those words import but this? Here is my name, written. I acknowledge that name written to have been written by me, bear witness. How is it possible that witnesses should swear that any signature was acknowledged unless they saw it? Your Honors, it is respectfully submitted that there is nothing in the evidence adduced at the trial that would suggest that the witnesses actually saw or had the opportunity of seeing the signature on the Guyana will. Your Honor, I must emphasize that the sole witness that spoke to the execution of the Guyana will, which is Dr. Jabor, he clearly stated that he was presented with 2 or 3 copies of documents, please, Your Honor. Because he had several documents in his possession at the time of the alleged acknowledgement, there is nothing of certainty to say that he actually saw the signature on the Guyana will at the time when the testator was allegedly acknowledging that signature, please, Your Honor. Your Honor, the other requirement is that that acknowledgement must have been in the presence of at least 2 witnesses. Again, when used within the confines of the section, presence is more than just a physical presence, please, Your Honor. That too was dealt with by Justice Lushington in Hudson and Parker, please, Your Honor. In that case, the learned justice said, the witness ought to be able to say, I was present and can attest the correctness. I was present and can attest its correctness, and does not the whole world understand this to mean mental and not bodily presence? A contrary construction will lead to an absurdity and defeat the plain intention of the statute, please, Your Honor. Once again, the court is reminded that there was only 1 witness that testified as to the execution of this will, which is Dr. Jabor. What this necessarily means, please, Your Honor, is that we have no evidence as to the mental presence of Dr. Kumar, please, Your Honor, at the time when the testator was allegedly acknowledging his signature, please, Your Honor. For these reasons, I submit that there is no compliance with this particular requirement of Section 4 of the Wills Act, please, Your Honor.
You agree that the Guyana Section 4 is different from the UK Section 4? The witnesses don't have to be present at the same time?
Yes,
They don't
please.
have to sign at the same time?
Yes, please.
Yes, they don't, or yes, they do?
There is a difference between the UK legislation and the Guyana legislation. What is required by our legislation is that they must both sign in the presence of the testator. The section is silent as to whether, or it doesn't say at all, that they ought to sign in the presence of each other. Your
And
Honor.
on the evidence, is the evidence that they signed in the presence of the testator?
No, please, Your Honor.
But you didn't bring that to our attention, did you? Is that a non-compliance with the section requirements?
Your Honor,
Are the witnesses required to sign in the presence of the testator?
the witnesses are required to sign in the presence of the testator.
In this
Yes, please.
case, did the 2 witnesses sign in the presence of the testator?
Your Honor, the evidence that was adduced at trial does not suggest that Dr. Kumar signed
Dr.
in
Kumar,
the presence.
it is suggested, signed in his office or something?
Yes, please, Your Honor.
So if we accept that, is that a compliance or a non-compliance with the
It
section?
would be a non-compliance, please, Your Honor.
And is that fatal?
Yes, of course, because the requirement is mandatory, as I earlier stated, please, Your Honor. Your Honor, I wish to proceed to ground of appeal C, which deals to the presumption of due execution.
If I may, you were saying something like, even if Dr. Kumar was physically present, he might not have been mentally present?
Your Honor, presence.
So I just want to know how that works.
So I am assuming but not conceding that if Dr. Kumar were physically present, there is no evidence as to his mental presence, because when used within the section, it's more than a physical presence. And I believe all the authorities are in agreement with
But
this.
Can you give me an example? I'm trying to imagine how that works, so that he is physically present but not mentally.
I would use the facts of this same case to provide that example. Dr. Kumar is, or was rather, the testator's attending physician. His purpose when he visits the ward is to look after his patient. So he may physically be in the ward when the testator is saying, well, answering Dr. Jabor's question, yes, this is my will, but his primary concern and focus would be to treat his patient. If that is the case, Your Honor, it would be an error to say that he was mentally present, and he can say with certainty that, yes, this gentleman acknowledged his signature in my presence, mental presence, that is.
But if he is physically present, wouldn't that mean generally that he is mentally present?
Not
Or
necessarily.
wouldn't you need something to show that probably he was not mentally present?
Your
I
Honor,
mean, normally when you're physically present, you're also mentally present.
normally, but there are exceptions to that,
Yes,
of course.
but then you need something that suggests that maybe here's an exception.
And Your Honor, that is where the lacuna is in this particular case, because again, that witness did not testify. So it's not for us to speculate, even if he were physically present, what was his mental presence at the time, please, Your Honors. So I think it would be dangerous for the court to try to speculate, well, because he was physically present, it would necessarily follow that he was mentally present as well.
Would it not be equally, wouldn't be equally so if we suggest or if we assume that he was not mentally present? I mean, when he's there, normally he would be mentally present, unless there's something where he was in another corner of the room doing something else or something, then you could maybe say, well, it's not clear that he was mentally present, so in this case you needed something more. But we don't know anything, huh?
Yes, please, Your Honor.
Okay, good.
Your case, though, is that he was not physically present.
Yes,
That
please.
he
I'm
signed in
merely
his office.
assuming. Yes, please.
I don't want to detain you long, but just help me with something. In the will, the Guyana will, the jurat, you have the will?
Yes, Your Honor.
Right. What does the attestation clause say?
The attestation clause said, signed by the said testator Yusuf Mongroo as his last will and testament in the presence of us both at the same time, who at his request and in his presence and in the presence of each other have subscribed our names as witnesses.
Good. So that is what, hold on a minute, that's what they are attested to. Is that true on the facts?
No, please, Your Honor.
What is not true about it?
Your Honor, in the first place, there was never a signing in the presence of the witnesses. It was always an acknowledgement.
So that's
please, Your
one.
Honor.
What
Yes.
else?
Secondly, on the evidence too, these witnesses were never in the presence of each other when they both signed as witnesses, please, Your Honor.
So, does the presumption of regularity apply?
No,
If
Your
the
Honor.
evidence contradicts the jurat, what are the implications of that?
Your Honor, that is the point I was going on to
Good.
make.
Excellent. Let's move on then.
Yes, please. Your Honors, when the attestation clause is at variance with what actually happened, the presumption does not apply. And this is clearly stated in the 2017 case of Wilson and Lastman, please, Your Honor. I just want to briefly read a portion of that decision. It says, where it was known and agreed that the attestation clause did not reflect the facts of the execution, and where due execution was alleged on another basis, there can be no room for the application of the presumption.
But what is the effect? Okay, so if that is the case here, let's just assume it is for now. So what?
Once the presumption of due execution is displaced, please, Your Honor, only there would need strong evidence then to show that all of the requirements of Section 4 have been complied with. And as discussed earlier, they have not been complied with as it relates to parts 3 and 4 of Section 4 of the Wills Act, please, Your Honor.
Is it counsel, Ms. Glenn?
Yes,
Yes,
please.
yes, ma'am. How did the Chief Justice, if she did, how did she reconcile that?
Your Honor, in her decision, where's the page? Here? one was reading from. Yes, please, Your Honor. At paragraph 181 of the Chief Justice's decision, and this is found at page 698 of the Record of Appeal, Her Honor said, while I appreciate that only one witness in Dr. Jabor testified, I am of the view that the totality of the evidence, including his, and that the presumption of regularity can be applied in this case, please, Your Honor. She goes on further to say, thus I hold that the Guyana will was properly executed in compliance with the Wills Act, Chapter 1202. So what appears to have happened here, Your Honor, is that the presumption of regularity was used as a reason to say that there was compliance with Section 4. And the two cannot go hand in hand. It's either there is compliance or there is a presumption of regularity, Your Honor.
So you say that's where the Chief Justice fell into error?
Yes, please, Your
Thank
Honor.
you.
Your Honor, finally, I wish to address the question of testamentary capacity, please, Your Honor. Your Honor, I would first begin by saying that the decisions of Justice of Appeal Gregory and our Chancellor Justice Cummins are different as it relates to the question of testamentary capacity. I would urge the court, however, to consider its decision, its 2017 decision of Ramsey Hall, please, Your Honor. Yes, it's your 2017 Ramsey Hall decision, and in that case, Your Honors, it is clearly stated that in exceptional circumstances, the court will review concurrent findings of fact of the court below. And of these exceptional circumstances, one includes where there is a lack of clarity or conflicting findings of fact, please, Your Honor. Your Honor, based on the reasoning of this court in that decision, I would respectfully submit that the contradiction between the two judges' decision does not prevent this court, as stated clearly in Ramsey Hall, from reviewing those concurrent findings of fact and making a determination on same, please, Your Honor, as it relates to the question of testamentary capacity.
But that was about concurring reasons.
Yes, please.
But who is concurring with whom?
Well, what is unique about this case, so there is Justice Gregory's decision and Justice Cummins' decision, but we have the third judge who said that he agreed with both. So in the very least, there is a concurrence with Justice Gregory's decision.
Yeah. But there is no concurrence with Justice Cummins.
Yes, but at least there's one concurrence, which is enough to activate this principle in the Ramsey Hall decision.
Well, it seems like a stretch to me, but who knows?
Your Honor, I'm merely
Thank
submitting. Your Honor, this would be the extent of my submissions unless there is something further I can be of assistance. Right. Thank you.
May it please Your Honors, I don't propose to delay you more than 5 minutes, and it's merely to say that the difficulty with the position we're at the end of the decisions of all three judges is the decision of Justice Persaud. There clearly is a conflict between the finding of fact, as accepted by Justice Gregory, on the question of testamentary capacity, where she accepts the findings of fact of the Chief Justice, and the finding of the Chancellor, which is contrary to that. The difficulty arises over the position adopted by Justice Persaud, who says he agrees with both. And what clearly arises out of that is a conflict, because he could not agree with the finding of fact in relation to the Chief Justice as upheld by Justice Gregory, and at the same time accept the findings of the Chancellor in relation to setting aside that finding of fact. I think the consequence of that is what perhaps troubles us today, and that is whether this should be remitted to Justice Persaud for him to clarify what aspects of either judgment he agreed with. Because even if this were you were persuaded to grant leave, I believe that question would confront you even if you were hearing the substantive opinion. And I don't think the brief judgment delivered by the Honorable Justice Persaud, merely saying that he agrees fully with the analysis and conclusions, leads us to a position where we know which analysis and which conclusion. I think the conclusion of both justices, both the Chancellor and Justice Gregory, is the same. The roots are completely different, and insofar as findings of fact are concerned, they are, I would say, on opposite ends in relation to testamentary capacity. And therefore, in those circumstances, Your Honor, I think the real issue is there any guidance that could be gathered from the judgment of His Honor Justice Persaud that indicates exactly what it was he was agreeing with when he said he agreed with the decisions of both of their honors. I fully adopt all that my learned friend who preceded me has, sorry.
Is there an option in resolving that dilemma of saying that the findings of the Chief Justice on that point should stand?
Well, it doesn't, assuming that we said we accept the findings of the Chief Justice in relation to testamentary capacity, when we come to the question of whether Section 4 of the Act was complied with, the Chief Justice herself did not make any finding on the second limb, which is that the testator acknowledged the contents of the will in the presence of both witnesses, whether together or separately, because there's no evidence. What the Chief Justice respectfully found, as a matter of fact, was, well, not as a matter of fact, what the Chief Justice sought to do was rely on the presumption of regularity. She specifically found, Your Honor, she says, and if I could, this is at page 696, line 40, since the evidence of the deceased was given on the will, on the 10th or 11th of August 2010, and Dr. Jabour saw the will signed at about 2 to 3 on the 12th of August, the strong inference is that the deceased signed the will before the witness would have signed it. I've also concluded that the evidence that he confirmed the contents of the will is sufficient for a finding that the deceased acknowledged his signature of it as being his will. That could only be in front of Dr. Jabour. Her Honor went on to say, the totality of the evidence, this is on page 697 at line 172, the totality of the evidence, coupled with that, the deceased previously requested the doctors to witness his will, which formed the evidence from which the evidence, sorry, well, sorry, it might have been a typo, which formed the evidence had to have been already signed, lends to the presumption of the execution. So Her Honor relies on the presumption, even though there was no finding at all that Dr. Kumar, either that the will was either acknowledged in his presence, in the presence of Dr. Jabour, or whether it was acknowledged by him.
So, like that, is it proper to have regard to the presumption, to apply the presumption?
No, I support what my learned friend preceding me said. There can be no presumption given those difficulties. And I think that was addressed specifically by the Chancellor in her decision. So, again, the problem lies with the contents of Justice Persaud's concurrence with both decisions.
So what exactly did he concur in the findings or in the conclusions? Or?
Well, therein lies the difficulty, Your Honor. There's no indication of whether he concurred with the findings, because they both were ad idem as to the result, but they certainly were not ad idem as to root. And the root was contradictory if you took the findings of fact by Justice Gregory, who accepted the trial judge's finding of fact in relation to testamentary capacity, or the Chancellor, who had a completely different finding in relation to that, because the Chancellor set aside the findings of fact by the learned trial judge and provided the reasons for the departure. That was very clear in her decision, and cited the decision of the Honorable Justice Winston Anderson in the Ramsey Hall case. So it wasn't as if she just departed from the findings of fact by the trial judge. She went on to say why she was departing of them. She indicated that she was aware that it is difficult to depart from them, and set out the basis upon which she was seeking to depart from that finding of fact. And in the grounds of appeal, there's no suggestion that that departure from by her was either unreasonable, was not based in fact, was one that was an outlier, for want of a better term. And so in those circumstances, whether addressed here or whether Your Honors were persuaded to grant leave, we will come back to this position. Oh, it's a substantive hearing. But in those cases, in those circumstances, Your Honor, I believe in the absence of any basis upon which one can determine what the Honorable Justice Persaud meant when he said he concurred with both, this court can either go back to the issues as they confronted the Chief Justice, and the clear evidence there, even in the Chief Justice's finding, was that there was no finding of the acknowledgement of the will in the presence of Dr. Kumar, whatever else one may want to address. And there was, of course, the other issues.
And that would vitiate the validity of the will, would it?
Indeed, Your Honor. But that is my submission, Your Honor. That is my submission, both on the grounds of non-compliance with Section 4, because the presumption would not apply, and of course the issues raised by the learned Chancellor. Unless I can be...
Mr. Hughes, I
sorry.
just want to hear you on two things. One is the Barbados will. Your take on that, and in particular, which you may not have thought of specifically, is what was the attestation clause in the Barbados will? I don't know if that's before us. I have not, I must confess, looked at it, but, or looked for it, but it's occurring to me now because Dr. Jaboud is presented with it, and it jogs his memory.
Right.
So it will be, first of all, what's your take on that? Well, because that's the evidence in the case, but I'm also curious to discover, did the Barbados will have the same jurat that the Guyanese will did, which if it did, and we are going to presume it to be accurate, then it is suggestive of a different execution process in relation to that will. In other words, if the Barbados will has the same jurat as the Guyanese will, right? We know that what happened in the Guyanese will is not what is described in the jurat. But if it is that we are going to take the Barbados will at face value, then what it means is what happened in the Barbados will is different from what happened in the Guyanese will. If you take the jurat in the Barbados will to be reflective of the truth of what happened, so that's why I'm asking you.
Sure.
I'm curious because it may be the jurat in the Barbados will is different. I don't know. So can you guide us on that and your general reflections on the Barbados will? Because of course, Mr. Karan says that is evidence of consistency. In other words, when Dr. Kumar is presented with it, he jogs him and he says, oh yes.
Dr.
Jaboud. He jogs his memory and he says, oh yes, you know, I'm very busy, so, this is exactly what happened. Well, therein lies, in my opinion, another dilemma. Because if he says this jogs my memory and this is what happened, then what is the jurat and the Barbados will saying happened? Do you understand what I'm asking?
I certainly do,
Your Honor.
Can
I just get your thoughts on that?
Your Honor, may I first briefly go to the context in which that arose, the purpose for which the Barbados will was used, and then I will address the question of the jurat. The Barbados will was introduced into the trial in re-examination after Dr. Jaboud had given substantially inconsistent testimony about whether or not he was present at the time of the execution of the will and whether or not Dr. Kumar was present either at the time of the execution of the will or at the time of the acknowledgement. There was leave sought by the witness, by counsel for the appellant in this case, to introduce the Barbados will only as an aid memoir. And that is important, because once it came in as an aide-memoire, and that triggered the memory of Dr. Jabour, counsel on the opposing side couldn't go to the contents of it, but could only, this was being used to say, yes, oh, I now remember accurately what allegedly took place. So I didn't get the impression that, even though it was tendered merely as a trigger to assist Dr. Jabour in recalling the sequence of events which he claimed he could not remember because of the number of patients, et cetera, et cetera, et cetera. So that's how that came in, and it came in re-examination. So there was no further opportunity for any of the parties to further cross him. In relation to Your Honor's question...
Pause.
Sorry.
So that after he was examined in re-examination of this new evidence, you were not given an opportunity to ask questions?
No, it came in re-examination, and there was no opportunity to ask questions on the...
I know, that's what I mean.
On the
After it was allowed to be used, you all were not permitted to
No, that
opportunity
was...
to ask
no,
anything?
No.
I see.
In relation to the content of the jurat and it being allowed into evidence for the truth of its content, i.e. what is stated there and executed by Dr. Jabour, whether that came in for the truth of the content, it couldn't properly be accepted as a previous consistent statement unless there was an allegation of inconsistency, and this was being used to contradict that. Because one is not allowed to enter into evidence a previous consistent statement for the purposes of, may I say, strengthening the quality of one's testimony. So to use it as a previous consistent statement, that would only be permissible under the Evidence Act if there was an allegation of inconsistency. And there was no allegation at all by any of the opposing parties, because that will was not tendered in chief. We were not allowed an opportunity to cross-examine and came in re-examination.
What does the attestation clause say?
Sorry, Your Honor?
What does the attestation clause say on the Barbados will?
Sorry, do we have it? It says...
It's the same as the guy.
Is this the Barbados will? Sorry, Your Honor, subject to correction. It says, signed by the above testator, the said Yusuf Mongroo for his last will and testament in the presence of us both present at the same time, who at his request and in his presence and of each other have hereunto subscribed our names, which didn't accept. That is not clearly what occurred.
Well, that's, for now, we have no evidence on what happened with the Barbados will.
None.
But what we can say is that is identical to what is stated on the Guyanese will.
I accept that.
In the Guyanese scenario is inaccurate.
Yes, please, Your Honor. That is our submission. Unless I can give further assistance, Your Honor, that concludes my submission. Thank you very much, Your Honor.
Is there anything further that you wish to put
Pardon
forward?
me, Your Honor.
Is there anything further that you wish to add?
Well, Your Honors will remember that my client is a beneficiary under the will, and we are arguing that in support of the appeal, even though we are on the side of the respondents. Just a few quick points, Your Honor. The Justice of Appeal Persaud could not have agreed in our submission with two inconsistent findings. I don't think that that is possible. And he can't, as suggested by my learned friend, Mr. Hughes, be called upon to correct or clarify whatever it is that he said after having delivered his judgment. So the way we look at it is that when Justice of Appeal Persaud agreed with both the Chancellor and Justice of Appeal Gregory, he could only have meant that he agreed with them on the due execution point. Yes. on the due execution point, the result on the due execution point, because he could not have agreed with them on the points that they differed on. So in our submission, that is the way that anomaly should be dealt with. On the Your Honors will find the case of Shannon and Perkins, a decision of the English Court of Appeal in 2005, an interesting decision on the question of due execution. In that case, two witnesses testified that they could not recall signing as witnesses. They said that they did not see the testator sign, and they said that they were not together with him in the room when he executed the will. The High Court judge in that case accepted this evidence and held that the will was non-compliant with Section 9 of the English Act. And even in those circumstances, Your Honor, the English Court of Appeal held, they reversed the trial judge and held that the presumption of due execution should have prevailed. Your Honors will see what Lord Justice Newberger, as he then was, said at paragraphs 9 and 10 of his judgment. He says as paragraph 10 that the principal reason for being reluctant to hold that a will properly executed on its face, representing the apparent wishes of the testator, should be set aside on extraneous evidence, is that one is thereby declining to implement the wishes of the testator following his death. That would be unfortunate, especially in a case he has taken care to ensure as far as he can that his wishes are given effect in a way which complies with the law. Your Honors will also see what Lady Justice Arden, as she then was, says at paragraph 50. She first mentions at paragraph 45 that only the strongest evidence can rebut the presumption of due execution. And she says this at paragraph 50. It follows that the courts should not be astute to find that the presumption as a due execution of a will, which is regularly executed and attested on its face, has been discharged. That is not to say that there will not be cases where the presumption is discharged. One such case is given by Lord Penzance, where both witnesses swear that the will was not duly executed, and there is no evidence the other way. Now, in this case, the case, first of all, demonstrates just how strong the presumption is, because there were clear findings by the trial judge that there was non-compliance, and the Court of Appeal felt that it was not strong enough. The evidence that the Court of Appeal, the English Court of Appeal, identified in this case that went the other way is evidence that the two witnesses who could not recall anything actually worked with the testator, Professor Channon, at the Manchester Business School where he was a professor. Now, in our case, the evidence, we have contradictory evidence, but the evidence that goes the other way is evidence from that very witness, from the very witness who witnessed the will, came from him. So in our submission, there was enough evidence going the other way, to use the language of Lady Justice Arden, to maintain the presumption. Now, Your Honors, the principle to be extracted from the cases which relate to poor recollection by witnesses is to us that the presumption of due execution dispenses with the need for detailed evidence or for complete evidence surrounding the execution of the will. In this case, by accepting the evidence of Dr. Jabour, the trial judge in our submission didn't even need to rely on the presumption. There was a finding of compliance made on the basis of the evidence of a witness to the will. And it would have been a very different matter, Your Honors, if none of the witnesses to the will had testified. In that case, the presumption would have to have been applied if the parties propounding the will intended to prove due execution. The presumption, Your Honor, captures all aspects of the execution of the will. It deals with the signing of the will, it deals with acknowledgement, it deals with the witnessing of the will, etc. All of these matters are caught by the presumption of due execution. And on the question of acknowledgement, which was raised by Justice Jamadar, in Blake and Knight, a case which is in our bundle, it was said that positive affirmative evidence and acknowledgement is not absolutely essential to the validity of a will. In that case, Your Honors, the fact that the testator said that the will was in his own handwriting was held to be sufficient acknowledgement. There is also the case cited by us of Gwilym and Gwilym, where the fact that the testator had asked two old ladies to witness his will was held to be sufficient acknowledgement. And there are two, in addition to what learned senior counsel pointed out to the court, there are two or three further pieces of evidence that I would like to point Your Honors to before I close on this acknowledgement, on the question of acknowledgement. Your Honors will see in the third paragraph of page 292 of the record, it's the evidence in chief of Dr. Jabour, where Dr. Jabour says that while he was in hospital, he asked me if I and Dr. Kumar would be witnesses to his will. And then it goes on to say in the same paragraph, Dr. Kumar was present when he told me this, and Dr. Kumar also agreed to witness the will. This is page 292, the third paragraph of the page. In our submission, that is sufficient acknowledgement. There is also, on the cross-examination by Mr. Hughes at page 363 of the record, the very, towards the bottom of page 363, the question put to the doctor in cross-examination by Mr. Hughes was this: at any time before that, did Mr. Mongroo even ask, or that should be ever ask you to sign? His answer was no. The next question, he told you to expect some documents and sign. And the answer of the witness, Dr. Jabour, was that he had asked me and Dr. Kumar together if we would sign his will for him. And we agreed, though we questioned him why he needed a will. And finally, Your Honor, I would like to refer you to the re-examination, which was not objected to, of Dr. Jabour at page 383. In the middle of that page. This is what the witness was asked. Was anyone in the room when you asked Mr. Mongroo whether he knew and understood who were the beneficiaries under the will? And his answer to that question was yes, Dr. Kumar. So, in our submission that there was sufficient acknowledgement, and in any event, acknowledgement can be presumed. There was some contradiction in the evidence. Most of the contradiction, contrary to what the Court of Appeal said, didn't arise in cross-examination. Almost all of it arose during examination in chief. And wherever there are gaps, whatever the gaps were, the Chief Justice accepted the evidence of Dr. Jabour. She accepted that his recollection may have been bad, and that was entirely within her domain. Unless there is anything else, Your Honor. Much obliged.
I was just wondering why you are a respondent. You sound more like a co-appellant, huh?
Well, our case throughout has been in support of the will.
Yes.
In the past, when we applied separately for leave to appeal and filed a separate notice of appeal, this court always consolidates it, and we end up making one set of submissions in the matter. So it saves us costs and time. Obliged, ma'am.
If it pleases Your Honor, less than 5 minutes. Not the 5 minutes that Mr. Hughes believes in. Your Honor, my friend, Mr. Satram, referred to page 383. In which he quoted a passage.
Is anyone in the room when you asked Mr. Mongroo whether he knew and understood who were the beneficiaries?
I didn't hear it. At 383, my friend mentioned it, Your Honor, and read the passage. Was anyone in the room with you? This is a question by the, I think by the court. Was anyone in the room with you when you asked Mr. Mongroo whether he knew and understood who were the beneficiaries? Yes, Dr. Kumar. But at page 350, Your Honors, at page 350, the court asked the question, where is Dr. Kumar when he signed the will? Where was Dr. Kumar, if I may repeat, Your Honor, when he signed the will? And this is a question by the court. He was at the foot of Mr. Mongroo's bed in his room at Mercy Hospital. So there is evidence that Mr. Mongroo signed the will. Later on, on this page, there is only one place to sign in the room. That is at the bed table. I signed, and then Dr. Kumar signed. So, Your Honor, there is ample evidence that Dr. Kumar signed the will. Her Honor did not make a finding specifically on Dr. Kumar signing. Her Honor does not have to make such a finding. But Her Honor says at page 697, paragraph 172, the totality of the evidence, coupled with that the deceased had previously requested the doctors to witness the will, which Mr. Satram referred to, which from the evidence had to have been already signed, lends to the presumption that the execution was properly done. Her Honor did not have to rely on the presumption of due execution because there was no gap in the evidence. There was no lack of evidence of due execution. The evidence was clear, and Her Honor so found. Your Honor, Your Honor, Justice Jamadar had asked about when the affidavit was signed, at what point in time, whether they were signed together. There was some question about that. At page 362 of the evidence, Your Honors, Dr. Jabour gave that evidence. He said, Your Honors, these are question and answers, I think probably by Her Honor, she didn't indicate. How many documents did you sign on 12th of August, re the will? However many pages there were several. Yes. Question, about 12, about 5 to 6. Question, what were these documents? Answer, yes. Were they the same documents? Yes, I was given a bundle of documents. So he was given a bundle of documents. The Guyana will was 2 copies, and he signed them. Your Honors, there was no need for a presumption of regularity. Your Honors, the evidence about the Barbados will was not introduced in cross-examination, in re-examination, Your Honor. The Barbados will was introduced by Ms. Sherene Mongroo in her examination in chief at page 137. The exhibit, the Barbados will, is at exhibit the oath for the Barbados will is at page 467. I can't.
Mr. Ramgaran,
I can't pick up the Barbados will at the moment.
Ramgaran, are we in the 5th minute now?
I bet. No, I'm at 4 minutes, Your Honor.
Okay.
Your Honor, the witness said I have the application for probate dated 30th of January, exhibit M1 to M10. And this is the point at page 137 that Sherene Mongroo tendered the Barbados will. Whatever the exhibit is, I can't pick it up at the moment in the list of exhibits. But the oath of the Barbados will, the oath is at page 467. The oath to which we are referring, which was tendered by Sherene Mongroo, is at exhibit M6. It's at page 467, M6. Your Honor, and here we have it. I have the application for probate by Sasedai Persaud, dated 20th of January 2011, tendered, exhibited marked, exhibit M1 to M10. Sherene Mongroo tendered it in her evidence in chief. It was not tendered in re-examination. And Dr. Jabour referred to it in his examination in chief. Your Honor, I have no idea how referring the matter back to Justice Persaud for a clarity as to his decision will function. If Justice Persaud makes a decision and the decision still comes out adverse to us, will we have a right to appeal again to the Caribbean Court of Justice? Just asking. Thank you, Your Honors.
Thank you very much, and thank you to counsel. We will take time to give our decision on this matter, and we'll let you know when we are ready with it.